Hi, everybody. I'm immigration lawyer John Khosravi. Thank you for joining us on our live show. Going live on YouTube, Facebook, LinkedIn, TikTok, and Instagram, where we take your general immigration questions about U.S. immigration live and try to give you some general perspective of what's going on because it could be a mess sometimes. So we're trying to do our best, trying to fill people in and trying to rectify the confusion that exists. And so we take your questions live here for the next half hour every Tuesday at 5 p.m. Pacific time. We're in a little early today, or excuse me, or at 8 p.m. Eastern time, 5 p.m. Pacific time. Again, take your questions about U.S. immigration live on all these different platforms. If you are watching on the live show, there's an additional benefit you have because we give away free video consultations. There's 3 of them where we can talk with a Zoom video consult in private about your case. All you gotta do is like and subscribe wherever you're watching this, and then just leave a question and write consultation at the end of it, or just write consultation once only. Don't repeat over and over again because that makes it hard to keep track of stuff. But we had a chance to get 3 different chances to win a live, a private consultation. I think it'll be a lot of fun. We're gonna discuss things a little more, a private scenario because we can't talk about everything here. Let me position my camera a little better for those watching. Okay, having said that, there's one more thing. We have an ultimate guide. It's called the JQK's Ultimate Marriage Green Card Guide, where we break down a lot of the stuff that's associated with the fiance or marriage-based case before you get started even talking to an immigration attorney. That way you can learn a lot about it and you can have a good consultation before you talk to a lawyer because you know the situation. It's 40 plus pages, helps out a lot. We got a lot of positive reviews on it. Thousands of people have read it and downloaded it, so I think you're going to enjoy it. We have a lot of people coming on board saying hi, Saima, Yvette, thank you, Afi, Arbel, thank you so much, everyone. So just send your questions over and we'll get the show started. So again, this is general education, not intended for individual legal guidance. But with that, we got some questions popping up. Deco asked, "Who's your prediction for the June Visa Bulletin?" Well, what is the Visa Bulletin in the first place? For most family and employment-based types of green cards, there's a limited number of these that are given out each year. However, there's a lot more people applying for them. So what happens is there's a line that develops over time, a backlog, if you will. And the Visa Bulletin is the system that they've created to keep track of who is in line for getting a green card. So when you submit and start your case, you get a priority date. That's the date that you have there. And then and then as cases move forward, they say, okay, people filed on, in February 2022, for example, who get their case approved. It just keeps moving. And sometimes it goes back and forth. This line doesn't necessarily move smoothly. A lot of it doesn't make much sense, frankly. But that's what the Visa Bulletin is. And if you're asking for my opinion on what the next one's going to be, I have none. I don't even think the Department of State knows itself. It kind of seems like they're making this stuff as they go along. So I wouldn't be able to answer that. And a guess isn't worth much. So we deal with facts over here, not guesses. But that's the best answer I got there. Thanks for asking. Ophir asks, I would like to ask, if I'm born in the United States, been here since 4 years old, then moved to Israel and came back here in the U.S. again at age 40, 2 years ago, can I use the I-864W for both of my kids' I-485s? Yeah, so the amount of time you're here doesn't matter if you're going to apply for their green cards and they're going to enter the United States or reside with you in the United States to get citizenship. That's what, for people who don't know, in this situation, even though Ophir was born in America, he does not, or he or she, I'm not sure, I think it's he. I'm not familiar with the name, sorry. But it does not transmit U.S. citizenship automatically to their children. Every time I post about this on social media, I get a bunch of hate emails saying I'm lying, I'm wrong, but no. For rules are right now is if you're born in the United States or a U.S. citizen, you have to have lived here for 5 years, 2 of which after the age of 14 minimum. And so in this situation, it seems like you may not have you may have now done it, but your kid's already born. So you didn't satisfy the requirements before they were born, so you didn't transmit citizenship to them. But now what you have to do is file for their green cards. And once they enter the United States, they could, and they reside with you here, they could apply for, U.S. passport, all that stuff. Good to get a form N-600 with that one. Now, the green card process has an affidavit of support requirement typically. It's one of the exceptions in this scenario where you don't have to do that. Now, the way you tell the government you have to do that is with Form I-864W, a waiver of the requirement. In practice, I've had embassies not even understand this exists, so be prepared for some uphill battle. But yeah, if you're going to be having children that are going to become citizens upon residing in the United States, the affidavit support requirement is waived. And so, yeah, you could use the I-864W for them. if this is the scenario you're going through. But thank you for your question, and hopefully that informed a lot of people about the complexity of the process. Eric Kicks asks, my wife got the CR1 interview appointment. Is it recommended for me to attend the interview with her, or should I just let her go to the embassy alone? Yeah, I mean, I can't recommend anything because you're not my client. I don't know the facts. If there's something wild going on in your case, I may need you to be there. But typically, it's not, for most cases, and almost all cases, it's not needed to bring the U.S. citizen spouse there. The foreign national, that foreign spouse, can go to the interview and handle it. That's typically what's done. Simon asks, with the current job situation, is it very hard to move L1 visa to an F1 visa? Okay, I think that you're just saying the job situation is hard for the L1. Is it hard to move out? The thing about changing status to an F1 category is the complexity involved with the timing of everything, how long it takes, and the cost associated with it. If you know what you're doing, it's not hard, but you have to fit your life and your funds and stuff into a certain methodology for it to happen. So if you could pull it off, no, it's not hard. I mean, it's just complex. But if someone's done it before, and we just have approval notice we posted, where a case like this was incorrectly denied, where someone had an H visa, H is like an L, a work visa, switching to an F, the government incorrectly denied it, and we had to appeal, and it was reopened within a month and fixed and approved. But it's so complex that even the government makes mistakes, so we have to fight them on it. But it is doable. We just got to make sure things match up, the timing of your essentially losing your job, the L1, the school you're going to sign up to, when you're registering. There's a lot of things that have to be talked about. So if you want to schedule a private consultation, Simon, feel free to reach out to email us, info@jqklaws email. We can talk more about it then. Melvin asks, greetings, John. Good to see you again. You as well, Melvin. Please, my wife isn't earning enough to sponsor me for I-130. I-130 doesn't need a sponsor. It's the affidavit of support needs a sponsor. But we got a sponsor that does. Does she still need to fill out the affidavit of support? Yes. Every person, when you, as I was speaking earlier, when you're doing a family-based case, there's an affidavit of support requirement. Now, let's say you're a wife applying for her husband who's a foreign person, and the wife doesn't make enough. It's just this scenario. You get a joint sponsor, someone else that can satisfy the financial requirement. Even if you do that, and the joint sponsor signs an affidavit of support from I-64, the spouse who does not make enough still has to sign that, because that is a contract with the government promising to support you. So she may not have enough money right now, maybe she does later, so the government wants her to be on the hook, and so be prepared for that. It is a requirement that she file one as well. Felice asks, is there any way to expedite my daughter's case at the National Visa Center, which became documentary qualified in June 2022? If there's no backlog, so it depends. Like if you have if your case is a child of a green card holder and your case is not, the priority date is not current, no, you can't do anything. But let's say you're a U.S. citizen or a case that is current, you could, if there's a good reason, try to request expedites from the government. And if it's really backed up and nothing's happening and it seems like almost a year now, you can file a lawsuit. It may work, it may not. We've seen it work before, where our firm is getting more and more involved because there's so much backlogs going through. We decided to file these group lawsuits against the government for these delays. So, it depends on your case, whether it's appropriate, whether it's stuck because the rules don't allow it, or stuck because the government's taking too long. Depending on one of those, you could potentially, request expedites, request that the government move forward, or potentially sue them for delay. And it may or may not work. We see it work again. But that's something you could do. If you're interested in that, just email the office and have a private consultation about your case. Exxon asks, I have an asylum case pending for interview. What will happen if I travel to another state? If you travel, that's you visit other states in the United States. That's fine. There's nothing wrong with that. This person, I can't read what their name is, but are USCIS agents trustworthy because I get different info from different agents? I don't know what you mean by trustworthy. They're employees that they're doing jobs, so I don't really understand the question. You're welcome, Melvin. Melvin says, thank you so much. I'm grateful. Look forward to seeing you one-on-one. Thank you. God bless you, Melvin. I appreciate it. Mandy asks, hey, sir, I got my medical exam I-693 form RFE notice. I don't see the question that follows up with that, but congrats. It's good that you got that. Really quick, I got to answer some questions on Instagram. I'm forgetting to get to. Sorry, everybody. I'll get you on Instagram in a second. But yeah, just respond to the RFE. Asks, if you're married with U.S. citizen, then after how many years can you apply for citizenship? Well, if you've been if you had a green card, I've been living with a U.S. citizen, married, living with a U.S. citizen for 3 years, you could potentially file faster at around the 3-year mark, but it depends on if you satisfy all the other immigration requirements as well. MRS, my USCIS account says that for the I-130 processing time is taking longer than expected. How many months or weeks must I wait to hear a decision? There's no deadline. It could be forever, unfortunately. On green card, can you take child benefit will affect on green card? Can you take child benefit will affect delay in citizenship? I'm not sure what that means, unfortunately. Mass asks, do you have to be a citizen for 10 years prior to transferring citizenship to the kids, or just be in America for 10 or 5 years? Or is it 5? So none of those, essentially. You have to have been living physically in the United States for 5 years, 2 of which are after the age of 14, and before the birth of the child. There's other sorts of formulas depending on what you're trying to do. If your parents are citizens too, or there are different things. The basic is that, but we have to really analyze your case to see what's going on there, because there's nuances to all this, and there's exceptions and all that kind of stuff. Master says, I got my citizenship from my father years, and many years later, there's a faster process of bringing my dog child over 21 and married. Okay, so you should have done it through your grandparents before they were 21. Now you got to just go through a long process. You can't transfer citizenship to them unless you had already transferred them somehow. So you have to look at the case. So at this point, Master is getting too complex. You got to definitely talk with an attorney in private or schedule a consultation so you look over the whole thing. Make sure I'm not missing something here. Shirog asks, hello. All right, everybody, can you hear me now? Let me know really quick. Katrina, can you hear me now? I think it works. Sorry, Manju. Okay, I'm back. Sorry about that. So, yeah, question just about your RFE. RFE is a request for evidence. That's when the government's missing something, and they want some more information. So when you're asking me what's the best evidence to send for a request for evidence, it depends on what it is. They may be asking for evidence of a relationship. They may be asking for proof of citizenship. They may be asking for a birth certificate. They may be asking for other kinds of documentation, missing information about your address history. So just saying that doesn't provide me any context of what you're asking. So I'm not able to answer that question. Sure, we need more details. But when it comes to an RFE, if you got one on I-130, definitely best to talk to an attorney in private. But thank you for your question. Tapone asks, can I adjust status if I enter the U.S. with a C1 visa? It was a transit only, not for C1D for crewmen. Apparently, there's a restriction for C1D, but not according to U.S. policy, not C1. So generally, the rules say for adjustment of status under Section INA 245, you cannot adjust status if you come in on a C or D visa. These are crew member visas and transit visas. There are some exceptions to it. For example, for crewmen, if you're not actually coming to be on the crew, but use it anyways. But this is there are exceptions to it. And you have to argue it and be very prepared. But this requires a factual review of your case to see exactly what happened. So I've heard it be approved before based on these exceptions, but it's something you want to be mindful of going. And you don't just want to file a case like that without doing the full research. Okay, Massa. I don't understand your answer on a green card. Can you take child benefits? Will affect your citizenship. So I don't know what you mean by child benefits. Massa and these are stuff I need to best talk in private. And that's that. If you're a green card holder, take child benefits. I'm guessing you get child benefits from the states and stuff like that. If the children are citizenships and they're entitled to them, then it may be okay. But it depends. We need more information. That's not something to answer quickly without knowing the benefit. It's something that's so important for you. I can't just say give individual legal guidance here. Next question. I have another question. If possible, my husband and my kids are under A1 visa. These are diplomats, and we will add Form I-508 with our Form I-485. Do you think this is because they're diplomats or case move fast or slow? It's unrelated that being diplomats, whether it be fast or slow, it's just, they're going to go in the system. Really quick, Instagram Massa. It seems there's a lot going on in your case. Definitely best to talk with an attorney in private. It's getting too much into like private factual analysis of your case, and this form isn't intended for that. It's just general quick kind of stuff. Our next case is Renee asked, "Hello, USCI sent me an email requesting my medical exam. They gave me 30 days to send. How long do I need to wait for response? Have they said a medical exam? There's no fixed time that you have to wait. It could be a week, it could be months, in years before they respond." Chinatown says, "I'm short $1,000 to sponsor my wife. Is that the way? Is that way to file?" So if you're short on your income level, you could substitute asset evidence of your assets, but that could get strict too. Embassies are not as helpful when you're using assets. So try to find a joint sponsor. Maybe that may be the way to go. Yeah, Massa, I said I can't answer your questions here. You got to schedule a private consultation for us to review your case. There's just too much factual stuff going on. This isn't the appropriate forum for that. Next question. I think with this person, I got told my case was going through adjudication, but other agents said it wasn't. If your case is not going to adjudication, when you look up your case number, it'll say so. It's been denied or stopped. So don't go by what the agent says. Go by what the case number is. If you want to call the case hotline, if there's confusion, ask your local congressperson to look into it. But at this point, it's better just talk to immigration in private to fill you in on what's going on with your case. A question: after approval of asylum application, when can I apply for a green card? Well, they changed the rules on this a few weeks ago or a month or two ago, and essentially, I'd have to research exactly how it is. But the time you spent typically the old rule was that if you get asylum, you'll file for U.S. citizenship 365 days or 1 year after getting asylum. They changed rules that it says now when they're adjudicating, the final decision is happening on your case, you have to have been here for 1 year. So does that mean like if you file the case and it takes them 1 year to approve it, you're okay, but if they try to prove it sooner, you're denied? I don't know the nuances of that. I haven't looked into it because I haven't ran into this case. I've been hired for this type of case yet to go really hardcore into it. But that's the update on the rule that they announced. I'm not really sure how it plays out yet. I haven't gone through. No one's really gone through because it just got changed about 45 days ago. Paul, one of regulars, I'm sorry to hear this. I received a notice of intent to deny requesting only my medical exam. Why not a regular RFE? Gave me 9 days to respond. Should I be worried? Yeah, I mean, I don't know why I was sending notice of intent to deny. I'm not sure if you should be worried or not. But if that's all they say, follow the instructions, and that's that. If that's all they ask. Coco says, "Hi, John. I received an RFE for tax transcripts, and my joint sponsor forgot to mention before that they sponsor someone before me to have enough income. What should be filed?" Well, you need to update the affidavit of support if that's the case, because you want to have truthful documents and say that it was incorrect. And RFE is a good time to tell them that, and also answer what they want. So they want tax transcripts. You got to get them tax transcripts. If it's not possible, you got to explain why. And have full tax return or something like that. Now, I got to mind you, I can't give individual legal guidance. I haven't read the RFE you got. I don't know the documents. This is just general kind of content only. But next question. Really quick. Okay, so user 308, Coco, actually, I do want to announce our winner for our first free consultation giveaway. Coco, if you're still watching, please take a screenshot where you're watching this so I know it's you, and email it to me at info@jqqlaw.com. That's info@jqqlaw.com, and the screenshot, and I'll send you information on scheduling a private consultation. For those just tuning in, we give away free video consultations. For those watching live show, we got 2 more to give away. All you got to do is like and subscribe and ask a good question, write consultation at the end of the question, or just say consultation once, and we'll randomly choose 2 more people before the end of the show. So next question really quick on Instagram. John Deere says, how to check interview backlog for spouse consular processing. There's no way to check how long the interview backlog is. JLo says, after I send my documents for proof of citizenship, how long does it take for them to respond? There's no timelines for them to respond. Lacey asks, why is the Atlanta field office so slow? I've been waiting for 1.5 years, and they said my interview is waived. 1.5 years isn't unfortunately slow, but this is just it's different for every case, not just the field office. Next question is user says, for N400 background checks, does the FBI call you to meet you in person? No, these are background checks they run digitally behind the scenes. Will asks, do I have I've been paroled to the United States. I came through the southern border. How about my WP? I'm work permit. You mean? I'm not sure what the regulations are on the work permits for those who are permitted on advanced parole. Saying they're asylees. I'm not sure what the rules on work permits for those are now. Dan asks, if DACA ends, should I get H4 through my H1B spouse? You should definitely look into that even sooner if it's appropriate for your case. That's something to look into, definitely. Maverick asks, is it better to travel internationally? Actually, Dan, that's a good question. My wonderful assistant Katrina named you as our winner for a lottery. So Dan, if you're still watching this, definitely take a screenshot of where you're watching this so I know it's you on your phone and stuff, and email me at info@jqqlaw.com. There's more to talk about here because you have to analyze whether if DACA suddenly ends, you'll start accumulating unlawful presence days. If you accumulate too much of those, it's problematic. So you really want to plan ahead of time. Potentially, you get DACA advanced parole to visit and get your H4 visa, come back to the H4, come back if it doesn't get approved, come back DACA. There's a lot of strategy involved in this kind of situation that you're in. So definitely take that screenshot, email me at info@jqqlaw.com, jqqlaw.com. We'll schedule a free private consultation to discuss in more detail. And for those just tuning in, we give away one more free video consultation. All you gotta do is like and subscribe. And either write consultation once or just ask a good question, write consultation. And my wonderful assistant, Katrina, will announce the winner behind the scenes to me, and I'll name it off. Maverick, guys, is it better to travel international before or after submitting N400? Currently have a pending I-751. It doesn't matter as long as you travel short, it's vacation, it's not intended for, moving addresses or something like that. It's all good. I want to ask, I got a green card through marriage, but asylum is pending. Can I travel to my country? Well, if you got your green card already, I'm not sure why you kept your asylum pending. And, I can't give individual legal guidance, but if your green card is not through asylum, I wouldn't typically be worried about it. But it depends. If you said in your asylum application, as soon as you go home, they're going to kill you, and then you go home and hang out, that could be fraud potential. So I haven't read your case. I don't know the details. I'm not sure why you have asylum case pending at this point if you got the green card. So talk with attorney in private. Coco, just a reminder, you did win a consultation. Take a screenshot while you're watching this and email it to info@jqqlaw.com. Katarina asks, my sister is 51-year-old, green card holder for 7 years. Can she take an interpreter for citizenship test? There's a rule for being able to take an interpreter, and I think the age has to be more and you have to be in the U.S. longer to take it. But if you look at Form N400 or read the instructions, it says what the rules are, how long you've been a green card, how old you are, to see what special benefits to give you with regard to the interpretation and stuff like that. Now just review what's there to see if you're matching with them. Edward says, can you speak to the moral turpitude standard immigration officers use during interview? Moral turpitude says essentially if the officer thinks you're a person of bad moral turpitude, they could deny your case. This typically applies to if there's criminal history, but even without that, they can make a decision. For example, it used to be if you cheated on your spouse, they would deny you because they didn't think you're moral turpitude. Typically nowadays is not something you use unless there's arrest or conviction history. It's not something we typically run into nowadays. User 97 says, if I'm a TPS holder, I came to the US to F1 and I didn't attend until I got TPS, my PPS by married green card wife. By married green card, I'm not sure your question isn't phrased properly. I'm not sure what you mean. IO says, recommend US approved verbally, call mail 2 weeks at a reschedule. Okay, you're saying the online website's not been updated. So online website doesn't necessarily get updated. Don't rely on that. It depends on what you get in the mail. So just wait for that. This is they had a green card interview and it was all over the place. Ali asks, hi, can my Iranian wife, green card holder, bring her parents to visit the U.S. from Iran? How long? It's not that she can bring or not bring. Her parents, your parents-in-law, your in-laws need to apply for their own tourist visas and get approved. So it's unrelated to your daughter, other than the fact that in the application for your parents that they fill out, it asks if they have children that's in the United States, and they write there. So they do that. How long? Well, you have to get an interview. In some places, getting it just interview appointments take 2 years, and sometimes consulates is less. And then after the interview, they may approve it, they may deny it. They may wait 6 months to deny it. They might take 1 year to approve it. So those are the real answers to your question, which is just do it if you want to do it and see what happens. Mark asked, I have a 2-year green card, but I recently noticed that the category showing my card was wrong. It said CR6, spouse of a citizen. but I'm a spouse of a resident. Do I need to do anything about that, or just file I-751? Just file I-751. It probably should have been like FX1 or something like that. FX1 is that what they do? But yeah, if you know the correct thing, just do it. Disregard that. Next question, Malik asked, what if you're charged with marriage fraud? What do you recommend in that situation to get rid of it? Well, I recommend getting a lawyer like immediately. Go get a lawyer. Marriage fraud is one of the most serious things that can be accused of. You want to be able to deal with that charge properly. It's not something to deal with. That's not something you want to mess around with. Heinz Castro, please stop asking the same question over again. I already answered it, first of all. But second of all, it's just filling up a lot of space here. Parent Andrew on regulars, good to see you. In the middle of adjustment of status, do O1 holders with husband and kids on O3 about to accept a new job offer need to file 539 with 929, family save money or afford? So if you have an adjustment of status pending, if you do a change of status or employer, they may just deny your case because you have adjustment of status pending. This goes into case specific stuff. I can't give you individual legal guidance here, but it's usually not needed to do it. Just make sure you don't violate your adjustment status if it's a good case. You don't have to maintain the underlying status. So that's that. But it goes too much into individual legal guidance. We word it here, so I can't answer more than that. User 3 says, I'm getting a call pretending FBI special agent want to meet for N400 investigation. Should I meet? No, they shouldn't call you. I mean, I don't know if it's really the FBI should, but I'm not sure if that's real or not. I'm not sure what's going on. It's a pretty serious situation. I'm not sure. You would know better than me if your case warrants it or not. So it's pretty serious. You should not be talking about this online. You should go talk with a lawyer in private. Rosha says, can you and your spouse income add up for marriage-based I-64? If the income is lawfully earned and it's included like in the tax return, yeah. But if you're here, for example, and you don't have work authorization, you're working, making money, you can't use that money. Ophir says, I'm unemployed since we arrived in the United States. My husband is working for 2 years as a diplomat and have a salary here in the U.S., but he didn't pay taxes here. Can we use a salary in I-64 and show the CPA? I'm not sure if he's a diplomat. I'm not sure how that is different on the I-64, if he could be on the hook for that or not. This is something that I would need to spend time looking into. I can't give a definite answer. Rich says, can an E2 visa holder apply for work permit? Which form should I fill out? If you're E2 visa holder, the primary, you don't need to apply for work permit. The job you have on the E2 that you're investing in, or you're was a petitioner, is your job, and you have automatic work authorization based on that. And recently, they changed it where if you arrive with an E2 I-94 as a spouse of an E2, so E2 primary and spouse have the same designation, you could work incident to just coming in. Haji says, can you apply for a travel document while spouse paper still processing? Well, it depends on what kind of travel document you're talking about. Travel document is like 4 or 5 different types of things. Maha says, I truly appreciate and love your lives every week. Thank you, Maha. I appreciate it. Thank you for giving people the peace of mind they need. You're welcome. God bless. I hope I can. Hat says, will misdemeanor B charge affect I-485? Maybe it depends on what the facts of the case were, what admissions were made. It depends on all like the court record, the police record, all that kind of stuff. I can't just tell you off. There's no exact response that just says misdemeanor B is okay. It depends on the facts of the case. Let me go back really quick to Instagram. I've been looking at that for a while. Let me see what questions. Should I? Lasori says, should I get a lawyer? You should have a lawyer to talk with. But MCAT says, what will happen after we sue the government for not scheduling an interview for a case been approved at NBC for 2.5 years? What will happen? We'll see either they'll schedule it, or deny your case, deny the court case, or they negotiate, they keep the can down the road. All sorts of different things can happen. If Forrest Cat says, I'm F1 and my permit is pending, at which stage of my green card application I may find a new job without losing my immigration status? It depends on what job you're going to. If you want to keep that perm, it's after you file I-485, it's been pending for 6 months. So it's going to be a while before you do something like that. Because in my case, it's been approved since 2022 and they didn't get an interview date. What should we do? Possibly faster. Contact the local congressperson to help you. Contact USCIS, the director, maybe even a lawsuit. But first, you can analyze your case to see if there's something specific that's wrong in your case. But December 2022 is, I don't know, it's been a while. So it depends on what kind of case you have. First, you got to analyze your case to see whether there's a reason for that, and then go through the steps of contacting the local field office, contacting a congressperson, contacting the ombudsman's office, maybe filing a lawsuit. So there's all this different kind of stuff. Next question. We're running out of time, so we're going to get a couple more. Nibra says, I missed my marriage-based immigration interview due to COVID. It's been 2 years, not rescheduled yet. I'm sorry to hear that. Is it constant processing? If so, you got to go ahead and reschedule yourself. Is it with USCIS? If so, you got to make sure they didn't deny your case and work with them to try to fix up the situation and get an interview. Brian says, my little bro that is depending on of her mom have an I-130, Pro. Can you make I-485? I don't know exactly what's going on. The verse of the sentence doesn't really help me out. Plus, there's just too much going on. I can't give fact-specific individual legal guidance here. Something we got to really analyze, see what's going on there. Okay. Jay asks, is it better to adjust status before you overstay your B2 visa? I mean, if depends on what the basis of your adjustment of status is. If it's based on marriage to a green card holder, you have to do it before your overstay B2 because they won't let you get it. But if it's marriage to a citizen, it's not necessarily. It really depends on the facts of the situation. And you're in luck. Katrina just notified me, a wonderful assistant, that you're a winner of our free video consultation. So take a screenshot while you're watching this so I can see it's you. Email it to me at info@immigrationlawyerstoolbox.com. And we'll set up a private time to chat a little more, give some more context around this, a better description there in private. We'll take 2 or 3 more questions. Let's see. Ian says, just got my F1 visa. Congrats. My employer wants to process my working visa. Can I apply for working visa? Potentially. It depends on what's going on, but you're not applying for working visa. Your employer starts the petition. Eventually, you apply for the visa. It depends on what kind of visa category it is, how long you're on F1. There's a lot going on. So I best to have your employer just schedule a consultation with us and talk about it to see what's going on. Next to the last question is Strauss. Hi, Strauss. I'm applying for adjustment of status. Came to U.S. on a tourist visa and overstayed. Should I disclose on the form that I work in the U.S. without authorization? Thank you. I can't give you individual legal guidance, but you have to be honest in the form. But be wary. If you had unauthorized employment, for some cases it could lead to denial. Also, if you had unauthorized employment and you claim to be U.S. citizen to get that job, that could lead to a denial and deportation removal. So be very careful. Talk with the immigration in private. That's that. Carol asks, can a joint sponsor not include his wife income if he makes nothing himself? They file jointly. Yes, they can, but you have to show the W-2s and 1099s to show your individual income separate from your spouse. Susan says, after 4 years of submitting I-751, they send me an interview soon. Why I expect this interview as advice? You're going to talk about your relationship and be able to bring documents and talk about it. That's about it. User 404 says, can I add my sibling with my mom in I-130 case together? No, you can't. U.S. citizen. Applying for the parent just applies for one parent. Siblings cannot come on top of that petition, unfortunately. And filing for sibling petition is going to take forever. So it's a little bit of a mess going on there. I want to thank everyone who joined us. God bless and be safe. There's enough questions for today. We're past the mark. But catch us again next week at 5 p.m. Pacific, 8 p.m. Eastern time to take your questions live about U.S. immigration law. If you want to schedule a private consultation, just email us at info@jqqlaw.com. I'm immigration lawyer John Kostrabi. Wish you all the best. Be safe, and until next one.